For better or worse, I may be Wisconsin's only Second Amendment attorney, and the better part is I get to meet all sorts of interesting people. I get to help people out. The downside, though, is that I have a lot of pressures on my time, and I would love to be able to talk to every single school administrator, teacher, parent, you name it, who reaches out to me with questions about firearms, schools, what can I do and when, what can my school do, what can my church do, what can my synagogue, my temple, my mosque, my whatever do. Well, I'm going to try to put a presentation that I've done previously for dozens of private schools before right here, so that way I'm happy to have these conversations, but I can't have the same conversation 2 times a week, 3 times a week, 45 minutes to educate every single person who comes down the pipeline. This video is intended to basically give you as much free information, push it out there to all of you as much as possible. There's no gatekeeping, there's no lawyers charging huge sums of money. Get the information out there, make sure people have it, and hopefully we can save as many children as possible in the process. Because today we're talking about Wisconsin schools and firearms law. I'm going to be breezing through a lot of slides for this presentation I've done before. I'm doing this because I know that you can pause this and freeze frame and look at things. So just keep in mind, I'm not doing this as I would an ordinary presentation. It's meant to be an hour-long or more presentation. So I'm going to be really pushing through this as quickly as possible here. Just keep in mind, nothing intended here is to create attorney-client privilege or anything like that. Keep in mind also that laws change with place and time. Update yourself, and also feel free to reach out not only to our law firm, grievelaw.com, but also, of course, by watching this YouTube channel, as I will periodically keep people updated. Now, this is a quote that I have on the wall of my lobby. Quote, "When you go into court, you are putting your fate into the hands of 12 people who weren't smart enough to get out of jury duty." Now, obviously, there's a lot of very intelligent, very serious people who enjoy performing civic duties. But holy smokes, if you've also seen some juries and jury pools out there too at the same time. Here's a quick where we're going. I'm not going to cover it all. I know the big ones are going to be when and how can you get firearms into schools lawfully? What does this mean for churches with attached parochial schools? And of course, schools and armed security. Those are the couple of the big places we're going to be going. There's a ton to cover, so let's get into it. So we need to build up our legal vocabulary here to understand what we need to pay attention to and what do we not need to pay attention to. So let's start with the concept of possession. Understand this. Ownership, generally immaterial when we're talking about criminal law. Generally, but not always. You got to understand that there's a lot of illegal things floating around out there. And when the cops come on the scene, they often don't belong to anyone. How did that get into that person's sock? Oh, I don't know. These aren't even my socks, right? Those of us who are old enough to have watched the show Cops know exactly what we're talking about. So you got to understand the law keys off of possession. Possession is an element of knowing possession in it. In other words, hey, I knew that this was here. I saw it was here, right? If I had a cell phone here, even if it wasn't my cell phone, if I saw the cell phone here, I'm now in knowing possession of it, even if I never actually touched it before, because then we get into the concept of constructive possession. Imagine you walk into a restaurant and there's a salt and pepper shaker on the table, right? You may have never been in that restaurant before. You've never seen that particular salt and pepper shaker. But when you sit down, you see it, you are now in constructive possession. In other words, you see it, you have knowledge, and if you reach out, you can touch it. That's the constructive possession. Knowledge plus access. So knowledge is really kind of a big key part. And you also notice I put a lot of sites in this presentation for you as well. So that's possession. But then we get the transport versus carry. And again, this is important because the law will treat these concepts differently, which means you need to as well. Transport is generally when we're not carrying the firearm. So if you imagine, basically, transport is this ledge up there, and anything that does not meet the transport criteria, which we generally want things to be in transport because there's more safe harbor provisions to get you out of trouble. So transport's generally good. As a criminal defense attorney, if we can get you into transport, that's typically a good spot to be at. And anything falls short of transport is typically now we're in carry land. So transport's when we're not using the firearm. We're basically taking it from A to B, and it's also encased, unloaded, and inaccessible. No, those are not all statutory, though 2 of them are encased and unloaded, but I also always throw in inaccessible because it's just by far best practice. If you check all 3 of those boxes, a firearm is encased, unloaded, and it's inaccessible, it's probably in transport. If you cannot check all 3, it may not be in transport. Important to understand, if you're talking about a revolver, any particular chamber loaded that's going to be a loaded firearm. If we're talking about a semi-automatic, we're talking about a Glock, a Beretta, an HK, a Smith & Wesson, whatever else it is, that's a semi-automatic firearm. Then if you have, generally speaking, if you have a loaded magazine that is beside the firearm, but it is not inserted in the magazine well, so it's seated beside the firearm, that's generally going to be considered unloaded for most of our purposes, okay? FAA, airplane, transportation, so forth, different conversation. But for our purposes, for today's discussion, that is unloaded. Make sure that that magazine, that loaded magazine, is not inserted into the firearm. So you can have a loaded magazine that's inserted, and even though there may not be a round in the chamber, that may still be counted as a loaded firearm. So you got to be careful about that. As I already mentioned before, carry is basically if you're not transporting. So if you don't meet all the criteria for transport, then you're probably carrying. I want to introduce an important concept called jury instructions. Jury instructions, which are now finally searchable in Wisconsin. It was copywritten by, conveniently, a wing of the government, wing of the state, but now you can actually look them all up online. If you ever tried to read statutory code, if you ever tried to read the laws as written by the legislature, you know that it's arcane and difficult sometimes, even for lawyers and law students. Jury instructions is basically a non-legally binding English translation of those laws in order to allow a judge to explain it to a layperson in the courtroom. Okay, so they are not legally binding, but they can be quite persuasive to help you understand here's what the law is. And again, you can Google that up, Wisconsin Criminal Jury Instructions. You'll see that sometimes I cite to it, such as here, Jury Instruction 1335, and then I put that in a little bit of quotes. But just important when you see that, that's what a jury instruction is. It's not law, but it's like law, and it's close to law, but it's definitely not law. So understand that when we talk about carry penalties, we talk about private property, so your home, a shopping mall, something like that, versus sensitive locations. And the reason why this is important is because, generally speaking, this is the delineation point between a forfeiture, in other words, that's code for a ticket, versus a crime. Private property with proper posting and refusal to leave equals a ticket. Generally speaking, there's exceptions. However, if you have a sensitive location, the mere presence plus knowledge equals a crime. And likely posting does not matter. So a sensitive location is a location that the government has determined if you bring a firearm here, that is illegal and that is likely going to be a crime here in Wisconsin. Keep in mind in other states, sometimes private property can also be a crime. So all these different things change with place and time. But here in Wisconsin, as of right now, this is the way the law works. And then I include a list of different sensitive locations here in Wisconsin. Of course, most prominently for our attention here today, we're talking about schools and school grounds. So here's a list of what we already covered: carry, transport, encase, loaded, unloaded, possession, and knowledge. It's time to actually go to school now that we've built some vocabulary. So what is a school? Well, Urban Dictionary tried to help us out here, who said that the definition of a school is the last remaining institution where child labor laws do not cover. I also asked my 15-year-old freshman daughter what is her definition of a school, to which she replied, and I quote, "It sucks the life out of you. Absolutely demoralizing experience every day. It is overwhelming and tiring, but you learn things." I mean, we got her to say something positive, so I'll take it. I'll also add she's like a 3.8 student taking, AP and honor roll stuff in freshman year, so got to brag on her a bit there. But if even she's saying that, it is what it is. Our actual definition of a school, because this is going to determine whether or not this particular location in question falls under the sensitive location, because it is a felony, as you will see, to possess a firearm without an applicable explanation, which is code for you've got to meet the statutory legal criteria, or else it's going to be a felony. So I threw it in here. The gist to it is this: if you offer any curriculum for any grade between 1 and 12, there's a good chance that these laws will apply to you, regardless of whether or not you're public, private, school choice, non-school choice, parochial, tribal, doesn't matter. Generally speaking, good chance if you offer any curriculum for grades 1 through 12, you're going to be a qualifying school. So likewise, it does beg the question, if we have a very specific definition for schools, what's our very specific definition of firearms? Well, I threw it up here for you. Firearms does not include any BB gun, any kind of pellet gun that expels a projectile through the force of pressurized air, or as well any starter pistols. For our purposes in this particular Wisconsin statute, those do not count. Otherwise, the term firearm basically means a weapon that acts by force of gunpowder. And you can also see that in the applicable jury instruction that I attached as well. So now we're going to get to the law. And the first one is we're going to start off campus as you approach. So this is Wisconsin statute. That's WisStat 948.605 sub 2 sub A. That's how you say that. I mean, you could say parentheses 2 parentheses A, but in law we say sub 2 sub A. So quote, any individual who knowingly possesses a firearm at a place that the individual knows or has a reasonable cause to believe is within 1,000 feet of the grounds of a school is subject to a Class B forfeiture. So that's code for you get a ticket. Now, this does not apply to folks who have concealed carry licenses in Wisconsin, and there's the relevant authority to that. So keep in mind, if you have a concealed carry license or if you're thinking about getting one, this is a great reason to have one. I will note, I started what is now by far the largest criminal defense firm in the state of Wisconsin. I have never seen this ticket issued, and we have a lot of data points, as you can imagine, a lot of data points, dozens of attorneys. Never seen this particular ticket issued. So not saying it's never been issued. I'm just saying it's one that they aren't popping everyone with left, right, and sideways. Here's the bigger one. Any individual who knowingly possesses a firearm at a place that the individual knows or has reasonable cause to believe is in or on the grounds of a school is guilty of a Class I felony. That's up to 3.5 years in prison, $10,000 fine, no good. Wisconsin statute 948.605 sub 2 sub A. Below this, you're going to see that there's a list of published exceptions. It does not apply per Wisconsin statute. You can see it, sub 2 sub B, when one of these things happen. Let's work through those. So the first one isn't an exception. It's actually a list of exceptions that it basically borrows from federal law. And you can see that's the 18 U.S.C. section 922 part up there. Now, importantly, I did leave it in, but I did put the strike through on there. You see that they actually omit numbers 2 and 3 of that list. So it actually goes from number 1 and then 4, 5, 6, 7. So number 1 basically says, look, it's the private property. It's not part of the school grounds. So for instance, if you owned a home that was your own private property, and for whatever reason you're surrounded by school grounds, that's private property, right? Likewise, if you're within 1,000 feet of a school and you don't have a concealed carry license, you don't necessarily need one if you're going to have a firearm at your own particular private property, or maybe that of a friend as well. So that's the sub 1 exception. We skip sub 2 and sub 3 to get to sub 4. Sub 4 is an interesting one. We're going to focus on these later. I'm not going to spend too much time on it, but it basically says, look, if you are an individual who is in possession of a firearm because of a program approved by the school in the school zone, then you can lawfully possess a firearm. Sub 5 basically says that if you're an individual who is possessing a firearm in accordance with the contract that's been entered into between the individual and the school in the school zone, then again, you can lawfully possess that. We're going to come back to that later, but maybe you can start to see some arguments and some opportunities for school resource officers who may not be uniformed police officers. And speaking of, then we get to sub 6, which basically gives an exception for law enforcement officers acting in their own official capacity. So this does not apply to people who may be off-duty police officers, at least not this particular exception. More on that in a bit. And then sub 7 deals with the somewhat more unusual exception where we're talking about an unloaded firearm that is being transported across school grounds to get to particular hunting grounds. Okay, now keep in mind that list of exceptions only came from one particular statute. I'm putting these statutes across the top of the screen here. So Schools and Guns, Wisconsin, statute 948.605, sub 2, sub B, sub 2D here. So this deals with a person who is employed in the state by a public agency as a law enforcement officer, and all the following applies. Basically, the person is a bona fide police officer who's been trained as authorized to carry firearms, and then there's none of the disqualifying factors below it, such as the fact it cannot be a machine gun or destructive device and so forth. Again, it's all up there on the screen. So this is where we're talking about potentially now off-duty police officers could then carry under this particular exception. Now, just like in-state qualified law enforcement officers can carry firearms on school grounds, likewise, out-of-state qualified law enforcement officers can also carry, subject to all of 1, 2, and 3 likewise applying. Now, certain times, former police officers, assuming they meet every single one of this criteria, can also carry. Now, oftentimes police officers will know this as HR 218. Others may know it as LEOSA. We're basically talking about effectively a special concealed carry license that sometimes former police officers, if they jump through the proper hoops, can have issued to them. Importantly, sometimes these licenses are issued to only be valid for a particular firearm down to that make, model, serial number of that particular firearm. Other times they may be very generalized to say any semi-automatic firearm or any handgun or any semi-automatic handgun, revolver, you name it. So just keep in mind that, folks, if you're thinking about this, you have to really make sure that you dot all of your I's and cross all of your T's to make sure that this applies to you. This is not something you want left up to a jury. Sub 2M deals with state certified commission wardens acting in their official capacity. Sub 3M deals with a person who is legally hunting in a school forest. If the school board has decided that hunting may be allowed in the school forest under, and then check that particular statute, 120.13 sub 38. Again, dot all of your I's, cross all of your T's. This is not something you want a jury deciding. Now, there is something that I call the parking lot exception, which comes from Wisconsin statute 948.605 sub 2 sub B sub 3. And it basically says this, that a person can possess a gun that is not loaded, as well as it has to be either encased, so unloaded and encased, or unloaded and is locked in a firearms rack in the motor vehicle. So unloaded, encased, or unloaded, locked in the firearms rack. Then according to that sub 3, you can actually have that in, I call that the parking lot exception. So in English, again, I cannot emphasize this enough, unloaded and either encased or locked in the firearms rack. I'm not going to spend any time on this. I'm just throwing up this text wall for you so that you understand that, look, just because it's not a firearm doesn't mean that it's necessarily legal. Dangerous weapons that are not firearms are subject to additional and separate regulation. Check out that slide. I'm also throwing this up here, but I'm not going to spend a lot of time on it because there are certain restrictions that are generally applied to all employers when we're dealing with concealed carry, such as the fact that an employer may not prohibit an employee from carrying a firearm in their own private vehicle on property. Exception for you, United States Postal Office workers, I suppose, until it perhaps gets overturned. But for most people, that's not a particular issue. Just throwing up a couple slides here on some employer restrictions. There's also this business liability immunity issue. I throw that up there for the curious. Basically, Wisconsin, when we passed our concealed carry statute, we made it so that businesses have an immunity shield to protect them if they allow employees and patrons and other folks to be able to conceal carry on site. So a lot of times, business owners, managers, decision makers, they are very risk-adverse creatures because they're being advised by attorneys, not this one, but people like me perhaps, and I'm so sorry about that. But they're being advised by very risk-adverse attorneys and who generally tell them, better not to have any kind of firearms on site on the premises of the business, for instance, because we don't want the liability. And what those folks need to understand, and the reason why I include it here, is you're actually opting into liability because while the Wisconsin legislature made it emphatically clear that if you allow firearms on the premises, there's a liability shield that protects you. If you bar them, it's not clear that you're going to be protected, and you actually could be subject to lawsuits under the theory that, hey, if you're going to disarm people from coming in, then are you guaranteeing or warranting that they're going to be protected? Are you assuming liability and risk for something does happen? If a robber or a bad guy comes in and does something evil and awful, are you protecting them? Now, the flip side of that is they could always turn around and not come in. So you would argue that there's an assumption of risk. But just keep in mind, you are choosing the risky option if you choose to block patrons in your establishment. Now, this may not, of course, apply to schools because, of course, you cannot opt out of this as schools, at least not at present time. But I'm just throwing this out there to spread the word on this subject. All right, church carry. I get this question quite a bit. And it usually goes something like this. Tom, I'm on my church security team, or I'm a parent, or I'm a pastor, or I'm whoever, and I'd love to be able to carry a firearm at my church on Sundays, on Wednesday night Bible study, on whatever it is, you name it, but there's an attached school. What are the laws there? Here's kind of the quick to-do list that I go through. Understand, again, this is not legal advice. These are general educational principles and guidelines. Number one, are there clear legal distinctions between the church and the school, such as zoning, separate parcels, etc.? And does the structural layout recognize these? So for instance, are these maybe a shared parking lot, but they have different legal parcels, and these are actually different structures that you have to, for instance, cross the parking lot from the church to get into the school and vice versa? Or is this one connected flow? Usually it's a connected flow, but if that's the case, is there a specific part that is clearly delineated as the school? Which brings me to number 2. Are there clear and obvious physical divisions? So for instance, are there locked school doors during class hours? Are there posted signs to make it emphatically clear that you are entering a school beyond this point? Also, time variabilities. I assume that a school is not ordinarily in session at 7 o'clock on Wednesday night or at 10 a.m. on Sunday morning. Let's make that clear with written policies, practices, and procedures and signs that are out there. None of this is going to be able to absolutely stop problems from happening. When I say problems, I'm talking about aggressive, anti-gun, politically minded prosecutors and perhaps even police officers, though more likely prosecutors, who might be going out there to try to go after folks who might be interested in concealed carrying at church. I'm far more worried about trying to basically mitigate these risks, understanding that I cannot turn it to zero because we have something called the rule of lenity. Rule of lenity is something the U.S. Supreme Court has invoked multiple times over just the last 5, 10, 20 years, deals with this. We don't want tyranny. You know how one of the ways you get tyranny if you study history? We're going to pass laws that could be interpreted any number of different ways, and then we're going to enforce those as we see fit. That's how you get tyranny, right? Because we're going to pick and choose who we're going to go after. The rule of lenity is this. We don't want tyranny. So if you have an ambiguous law, the tie ought to go to the defendant if they can offer a reasonable interpretation. So what I'm trying to do here by this risk mitigation strategy of exploring the use of signage, of written policies, of developing time codes for when this is a church versus when this is a school and so forth, is we're trying to basically muddy up the waters as much as possible for a prosecution so that folks on your security team, so that parents, whoever it is that you have carrying, can carry with as clean and clear conscience as possible to save as many lives as possible rather than being at maximum risk of going to prison. Because this slide, and this is probably not news to many of you, but cops, prosecutors, judges, and juries will vary radically from place to place. The same is true in any state, and Wisconsin is certainly no exception. There are different attitudes and outcomes for the same exact fact patterns that you can have in different spots in Wisconsin. Case in point, if you were to drop the exact same set of police reports alleging the exact same fact pattern, you put one in Milwaukee County, one in Waukesha County, one in Dane County, let's sprinkle one up north somewhere, you may get 4 very different outcomes depending upon exactly what those prosecutors, what are the norms and attitudes of the prosecutors, the judges, and the jury pools, not to mention potentially the defense attorneys as well. Clear written policies and procedures are often the best way to communicate with not only employees as well as parents and families, but also juries and the media as well. And keep in mind, to that point, anything you put in writing will be used to communicate to all of those groups and many others. Here's my bottom line on this. People can read the law and reach radically different conclusions. Carrying or possessing a firearm in a church attached to a school is a legal risk, and I want to make no bones about that. That risk is significantly heightened if you want to talk about carrying a firearm in a school under a program or contract requirement, which we're going to get to in a couple moments. Competent counsel needs to be sought to ensure that people understand these risks. Competent counsel, and we have drafted these here for schools, so reach out to us, grievelaw.com, but competent counsel needs to be sought to make sure that we can proactively engage with local district attorneys, local law enforcement, to do everything possible to make sure that all of the stakeholders are going to be knowledgeable and in place about what's going on, not because that will eliminate risk. If the prosecutor says, if you do this, we will not prosecute you because you've got this contract with this security personnel or something like that. You cannot contract your way out of that. But you can at least reduce your chances of running into that down the road. Which brings us to finally armed security on campus. How do we get people following the law to be able to lawfully carry on campus? Well, here's a text wall of different approaches to it. The gist to it is this. There is a security resource officer statute that are out there that largely applies to first-class cities. That's code for Milwaukee, by the way, okay, which basically mandates a lot of different policies and procedures. I'm setting that to the side because I realize that most of you out there are probably not part of Milwaukee Public Schools or something like that. Understand, however, that there may be some legal resources out there if you do want to reach out to a local law enforcement department to partner with them about getting maybe particular days of a week or for particular events, or maybe full time, depending on where you are. Now, you're going to have to figure out the funding splits with them, and I'm sure that if you're an administrator and you're watching this, you know all about what I'm talking about there. But you can basically have some legal pathways forward on how you can get an SRO, a security resource officer, on site on campus under those applicable Wisconsin statutes. But what happens if maybe that's just cost prohibitive or your local chief of police or sheriff just isn't interested? Well, that gets us back to what we talked about before. That's Wisconsin Statute 948.605, sub 2, sub B, sub 1M. So we're talking about now basically creating contracts and programs to basically exercise those 1M exceptions that were created under federal law to allow, in essence, a security resource officer, or however it is you want to phrase it, who may not be a regular deputized or sworn in public agency law enforcement officer. Maybe they're a retired law enforcement officer. Maybe they're just a trusted, trained, highly responsible, known individual. Don't know. Understand that there are some options here. They have not been tested, to my knowledge, in Wisconsin. So these are here, but they have not been courtroom tested. We have done this for different schools. So if you're interested in this, feel free to reach out. We've got easy flat fees on it. Up to you. But there are pathways forward. Understand that the risk is not zero. Contact us for more options on that. Understand, however, as well that there are extra options that are out there, or extra protections that are out there, like a belt and suspenders, if you are choosing to employ as part of that private security resource detail former law enforcement officers who might be protected under something like HR 218, otherwise known as LEOSA. Also, lastly, keep in mind that certain municipalities, like for instance Milwaukee, may have certain municipal code and other ordinances and regulations you need to comply with as well. Not something I want to dwell on, but just something I want to throw out there and introduce as a concept for you as well. So that's a ton covered, but wait, here's some more, because we have to have a little bit of fun with this because we're 35 minutes or so in at this point. Understand, and I'm not going to go through all this right now, that all Second Amendment law is changing fast. When I say fast, there have been more gun laws struck down and changed in the second half of 2022 than in the preceding 200 plus years of history and tradition and jurisprudence in the entire United States combined. So understand that this stuff is changing, and it's changing quickly. I've given you across a couple different slides, different cases that are up there already in front of the U.S. Supreme Court, with I think more to come as well. I also included a brief summary of Wisconsin deadly force and force law. Keep in mind, this is not legally binding. This is educational, giving you the sites, because frankly, a lot of people don't know it and they need to know it. And I'd rather give you something rather than nothing. Up here on this slide, how the government teaches the law. This is kind of a easy breakdown that I ripped off a federal training slides some years ago now, because it has nothing to do with state-specific law, but it gets to general principles that you can teach to that travel pretty nicely across all 50 states. Of course, we can do better than that here because we're dealing with Wisconsin law. I'm more than happy to talk to your folks about Wisconsin law if you do have those questions. Also understand that when it comes to true threat speech, that the Supreme Court in 2023 in the Counterman versus Colorado case did adopt a rule that speech is not protected if the speaker is consciously disregarded a substantial risk that his communication would be viewed as threatening violence. I understand that typically every single discussion about speech invariably winds up as that's free speech. Well, understand that you get to these so-called true threats is one of the 5 categories of free speech that is not free speech. It's just unprotected speech. So that's it. I hope that you enjoyed this presentation. Again, I went through things extremely quickly. There's so much I didn't cover, but I wanted to at least give a common starting point for free to get the information out there to help protect as many lives as possible so that it's not gatekept behind, well, me and my knowledge base or something like that. I wanted to get it out there for folks to start those discussions. Always feel free to reach out. I appreciate you tuning in. Don't forget that like button, all the normal YouTube stuff if you enjoy basically public service announcement videos like this, and if you want to see more of them. We appreciate you, and we'll see you in the next one. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.